Today, we have the pleasure of having as a guest Ashit Srivastava, who is assistant professor in law at Dharamashastra National Law University. Ashit has already collaborated with us on a series of presentations related to the digital constitutionalism discussion group, is an active researcher in this field, and today he will be delivering a presentation on the growth of digital constitutionalism in India. So when you're ready, Ashit, the floor is yours. Thank you very much.
Yes, thank you so much, sir, for introducing me and giving me this again an opportunity to present my side of digital constitutionalism from Indian perspective. We already are seeing a global phenomenon of growth of digital constitutionalism across the globe. We are seeing that countries are coming up with the data protection regime, and India is one of the countries which is trying to do that right now. Seeing the growth of digital constitutionalism, let us trickle down this concept to this basic idea. It's basically an idea of safeguarding the information, and we know the best way of safeguarding the information will come with an idea of regulation of data. And we see that the GDPR is becoming a template model for all of us to follow. And not only India, if I see South Asia, we realize that South Asia in toto has drawn a lot of inspiration from GDPR. So in that relevance, I can surely say that GDPR is the template model which we are trying to follow. But let's come back to the idea of India as to how this is growing in India, how digital constitutionalism, how the idea of data protection has taken its seeds in India, and it is growing into a great blossom tree. So this all story starts with 2017 when we had this major judgment of case Swami coming into existence. Now, the great thing about the judgment was that the judgment recognized three facets of privacy. It says that, that privacy is a part of human dignity. We all agree with that idea. And it says privacy is not only about only an aspect of privacy. There are three aspects to privacy. It says informational privacy, privacy of mind, and bodily privacy. So as Indians, we already knew about the idea of bodily privacy. That we have a physical space. We're trying to safeguard the physical space, and we respect the physical space. That's the idea of privacy of the body. Privacy of the mind is something which we talk about when we talk about criminal law, basically the mental integrity or mental privacy. Informational privacy is a new element to our set of knowledge. Now, for a country which has suddenly recognized privacy, that to informational privacy in 2017, it becomes a lot of catching up role to play, because you come to realize the European GDPR or the European Union per se was already so conscious about this idea of privacy and data protection till from 1990s onward itself, that when India recognizes the idea of privacy or even informational privacy in 2017, it's a gap of 27 years. So when we recognize privacy, when we say, we have informational privacy. Now, what is informational privacy? Informational privacy literally means that, I have an ownership over my information. Now, that basic idea also brings in a perspective of how should I safeguard my information? Because the main threat against my information is not coming from the state actor. It is coming from a non-state actor, right? Now, this particular idea pushes me to have, this idea pushes me to control my information. And I know, because a lot of power is with the non-state actor, how to control that information which is there in this digital world. Because if it's a physical dignity, I can always say, I have a dignity, you cannot reach my dignity, and in this physical space, I do that. But when it comes to information, we know information is sustainable in nature. And once the information is in the digital world, how do I maintain my control? This is the whole idea of resistance. Because information generates resistance, and this time the resistance is not against the state actor, but it is also against the non-state actor. Because the amount of harm the state actor can do against me, equal amount of harm can be done with the non-state actor against me, right? So this is a time that we need to recognize that information has the same amount of value as human dignity in a physical world. Now, we're trying to safeguard that information. The information is the basis of our digital dignity. How to safeguard it? We require to have a data protection regulation. I'll share one particular diagram with you for better understanding of this idea. Let me know if my screen is visible to you. Hopefully the screen is visible. Can you see my screen? Yeah. So this is a diagram of the judgment of K.S. Swami which came out in 2017, right? And If you see the diagram carefully, and this is again a lot of imagination which I have put into while I'm making this diagram. If you see it carefully, they have recognized privacy as a facet of human dignity, which we all are accepting that privacy, because to exercise human dignity, we require privacy. Because unless we have privacy, we cannot have a functional usage of dignity, because that's of no use. Because if I am in presence of any individual, I will always be under pressure, and I'll be thinking, that individual is still here. I will not able to make my own life choices. So if I want to make my life choices, I want to have privacy. So privacy has a functional relationship with human dignity. We cannot deny that fact, and it is recognized. And if you see carefully, the 2017 judgment recognizes privacy with three other features: informational privacy, privacy of mind, and bodily privacy. Very good, right? You come to realize that informational privacy needs to be safeguarded through a means of data protection law. Right? Now, there is a problem coming in, because our sense of jurisprudence in 2017, when we recognized this idea of privacy and informational privacy to be there, we are not recognizing data protection law as a facet of human dignity. We are recognizing data protection law as a facet of informational privacy. But we are not seeing a direct linkage between human dignity and data protection law. Because when I see this jurisprudence as compared to EU jurisprudence, European Union, they already recognize data protection law as a part of the fundamental right. And if I'm not wrong, Article 8 of the EU Charters on Fundamental Rights 2000, Article 8 quite correctly says that data protection law is also a part of the fundamental rights, because they are regarding it as a facet of human dignity, right? So now, and I'll tell you why this creates a fallacy in jurisprudence of digital constitutionalism. I'll tell you why. You see this chart, you come to realize that we are recognizing informational privacy, and to safeguard informational privacy, we require data protection law, but we are not recognizing data protection law as a part of human dignity. And I'll tell you why this is a flawed aspect. Okay, if I'm continuing to share my screen. If you can just see this particular diagram, right? I'll just move this screen from here to here, so the screen is much more lively. And this is what I call as reverse engineering of digital constitutionalism. Because if anyone who picks up the data protection bill, and I'll tell you why, because in 2017, and the sequence comes in. In 2017, we recognized this idea of informational privacy, that there is informational privacy. Now, when we recognize this aspect, we also need to safeguard informational privacy. So we make a personal data protection bill 2018, which has been replaced by a bill in 2019, right? And it is still under consideration in the parliament right now. So the possibility there might be a few more changes coming in. But a lot of amount of provisions of the personal data protection bill are inspired by GDPR. Okay, so if I'm seeing GDPR as a tool which is reflective of digital constitutionalism, because I can quite correctly say, what the GDPR is trying to ensure digital dignity. Why? Because it is respecting someone's personal data protection laws, right, as a fundamental right, right? So if I say that GDPR is a reflection of digital constitutionalism, and our PDB bill 2018 and 29, when I say PDB bill, I really mean Personal Data Protection Bill 2018-29, they are inspired by GDPR. By not, and we do not recognize information, or we do not recognize data protection law as a part of human dignity in our jurisprudence. But by making that bill, which is reflecting on GDPR, they're reverse engineering the process itself, right? Because by default, we are getting inspired by a document which is regarding the idea of informational privacy or data protection as a part of human dignity. So there is a fallacy which we need to understand much more deeply upon this perspective. We till now, because in 2017 we have not recognized the idea of data protection law. It has created a big problem, because our sense of personal data is not very conscious right now. We are trying to replicate what the other country has done. So it will take a lot of time to grow that conscious, to be able to create a document which is much more acceptable and much more understandable of all other issues of data protection. And this is where I really find that the GDPR might be an advanced document per se. Then that it is trying to inculcate all those aspects of personal lives which are capable of creating metadata, and even keeping the stock of all those metadata, that what this personal data can be utilized for understanding an individual. So our sense of jurisprudence is still growing on. It is only in 2017 when we recognize that what informational privacy is a part of privacy. Now to grow that sense of jurisprudence from 2017 till now will take a lot of time, because we're still getting used to the idea of privacy. So once we get used to the idea of privacy, then we'll get used to the idea of informational privacy. There's still several of e-commerce websites working in India who are not giving any kind of attention to the idea of informational privacy. And if I visit any e-commerce website today in India, and if I read the privacy policy, they quite clearly say, if I visit the website, I'm bound by the terms and conditions. Any individual who's living in the European Union today will come to realize this fact that if something terms are like these of e-commerce website, you easily sue the company. So you know what? That is not my consent. It's the breach of my consent. But our sense of privacy is so backward right now, or our sense of information privacy has not grown that much. We are not able to accept this fact right now. Right? Keeping on the same front line, and I think this is much more of a South Asian phenomenon which is coming up right now. So we realize this fact that the greatest threat against information, and again when I say greatest threat of information, I'm seeing the idea of information per se as a tool of resistance. Because I come to realize, because if I have to safeguard my information, I'm not doing it only against the state actor, against non-state actor as well. And most of the non-state actors were mostly of Western corporations, right? So suddenly the South Asian countries are realizing this fact that, what, if we want to reclaim our sense of dignity or our sense of sovereignty, we can only do it through the means of data localization. That, what, we need to grow back our dependency on ourselves. So they are seeing a data localization as a tool of reclaiming the idea of sovereignty and integrity. That, what, till how far can we allow non-state actors to govern our sense of jurisprudence for way too long? And there's this idea of data localization which has just come forward in the South Asian context, because it's not only India, it's all other South Asian countries are suddenly pushing for data localization, because they are realizing this fact. Their sense of jurisprudence or information privacy was not that forward, and they did not understand what implication it could have until after the 2016 US election. A lot of people came to realize that, what implication it could have. It is after only those terms that they realize, what, the data has a lot of power and tool for manipulating people and manipulating democracies. So they said, what, the Western corporations might not be doing a good job for our democracy. We need to reclaim the idea of sovereignty, and that could only happen with data localization. There are several other implications upon that, but I won't touch upon that right now. I'll limit myself to this perspective to give you upon digital constitutionalism in India right now. If I summarize my perspective of digital constitutionalism in India, I can only tell right now, our sense of jurisprudence on digital constitutionalism, or even taking information as a basis of resistance, is a little back right now. It's not a front, or is not as advanced as GDPR's perspective has grown right now. So we are trying to replicate what has happened there, and we're trying to bring the same sense of jurisprudence here in India, which will again take a lot of time and a lot of growth which is required, because we are not teaching this idea of consciousness which GDPR is reflecting right now in data protection regime in India right now. Yes.